Welcome to Details of Divorce, where we break down the legal, financial, and emotional aspects of divorce to help you make informed decisions. I'm your host, Paul Riley, and each episode we dive into key issues that impact individuals navigating separation and divorce. So, whether you're concerned about asset division, protecting your business, or dealing with foreign property disputes, we are here to provide clear and practical insights. And today's episode, I think, will resonate with many of you because we deal with some of these files and they are always difficult. Military service. Military service demands sacrifice, not just from those who serve, but from their families as well. When military marriages end and postings require relocation, the intersection of professional duty and parental responsibility creates some of the most challenging and difficult disputes in family law. Today, we'll examine how Ontario courts balance military career obligations against the fundamental principles governing all family decisions, the best interests of the child. Under both Ontario's Children's Law Reform Act and the Federal Divorce Act, courts apply one paramount principle when addressing relocation requests: the child's best interest. This isn't merely a consideration. In fact, it's the exclusive test. Courts must give primary consideration to the child's physical, emotional, and psychological safety, security, and well-being. The 2021 amendments to the Divorce Act codified decades of jurisprudence, creating a comprehensive framework that specifically addresses relocation scenarios. These changes didn't eliminate judicial discretion, but they provided clearer guidance, I think it's fair to say, on burden of proof and factors that the courts must consider. Military postings present unique challenges because there often aren't any options. However, courts have consistently held that military employment doesn't automatically justify relocating with children. The necessity of the posting and the impact on the child's best interest requires careful and rigorous scrutiny. Let's examine two contrasting outcomes. In Scoo v. Fzen, the Ontario Superior Court permitted a lieutenant commander with the Royal Canadian Navy to relocate temporarily with her children for a career development course. The court found the posting was mandatory, refusal would harm her career, and this enhanced the children's economic well-being. Crucially, the mother complied with notice requirements and the children spent the vast majority of time in her care. Similarly, in Cornelis v. Cornelis, a mother was permitted to relocate to Germany due to her new husband's U.S. military posting. The court emphasized her well-researched plan for the children's care and her consistent support of their relationship with their father. Conversely, in Tabert v. Walker, a warrant officer with the Canadian Armed Forces was denied permission to relocate the children to Kingston, despite her move being required for employment. The critical factor here, the children had shared parenting time with both parents, not primarily with the relocating parent. The court found the move wouldn't enhance the children's economic circumstances and noted the possibility of future postings causing additional disruption as well. In Beg v. Pariso, a operating room technician was denied interim relocation to Petawawa for promotion. In that case, the court found that her evidence contradicted and noted that pay increases alone don't constitute compelling reasons for disrupting children's established arrangements. Understanding who bears the burden of proof is crucial in relocation cases. The framework depends on the existing parent's arrangement. If children spend substantially equal time with each parent, the relocating parent must prove the move serves the child's best interest. If children spend the vast majority of time with the relocating parent, the opposing parent must prove that the move doesn't serve the child's best interest. All other cases, both parties bear the burden of proving their position. This framework recognizes that disrupting established primary caregiving relationships requires stronger justification than just maintaining them. Beyond the burden of proof, courts examine multiple factors to decide how to render a decision. Reasons for the relocation is one. Military postings are legitimate reasons, but courts scrutinize whether they're truly mandatory and beneficial to the family unit. Career advancement and financial stability carry weight, but not if they primarily serve the parent's interests rather than the child's. Impact on child-parent relationship is another factor. Courts carefully consider how relocation affects a child's relationship with both parents. Technology can maintain communication, but it cannot fully replace regular in-person contact for meaningful relationship development with a parent. Compliance with notice requirements is key as well. The Divorce Act requires 60 days notice before relocation. Non-compliance seriously undermines a parent's position, as seen in Pret-Legard v. Pret-Legard, where the mother's failure to provide notice contributed to an order requiring the child's return. Stability in community ties is also key. Courts examine the child's established relationships with extended family, school, and community. Long-established roots carry significant weight against disruption. Military families face unique challenges that the courts do recognize. Future posting. Courts consider the likelihood of additional moves. In Tabert v. Walker, the possibility of future postings was a factor against permitting relocation, as it suggested ongoing instability. Career consequences is also key. Courts acknowledge that refusing military postings can have severe career implications, including forced release from service. This factor supported relocation in Scoo v. Fzen. Economic benefits is key. Military careers often provide stable, well-compensated employment with comprehensive benefits. Courts weigh these advantages for the children's long-term security as well. Support networks, obviously, is also key, and military communities often provide strong support systems. But courts also consider family support available at either location as well. For military families facing potential relocation disputes, here is what you should do. 1, early planning. Don't wait for posting orders. If military service involves potential relocation, address this possibility in separation agreements or custody orders. 2, documentation. Maintain clear records of parenting time, compliance with existing orders, and the child's adjustment to military life. 3, communication. Engage early with the other parent about potential moves. Courts favor parents who make good faith efforts to accommodate both parents' interests. 4, professional support. Consider involving mental health professionals to assess the child's adjustment to military life and potential moves. Military service creates unavoidable tensions between professional obligations and family responsibilities. Ontario's courts have developed sophisticated approaches to balance these competing demands while maintaining focus on what matters most, the child's best interest. Military families should understand that postings alone don't guarantee successful relocation applications. Success depends on demonstrating that the move genuinely serves the child's long-term welfare, maintaining compliance with legal requirements, and presenting realistic plans for preserving important relationships. Military service requires sacrifice, but that sacrifice should not come at the expense of children's fundamental needs for stability and meaningful relationship with both parents. The court's role in ensuring that military obligations serve rather than undermine the next generation's welfare. That's it for this episode in Details in Divorce. We hope you found today's discussion insightful and valuable as you navigate your own divorce journey. Remember, every situation is unique, and getting the right information is key to making the best decisions for your future. If you have any questions or need guidance, the Riley firm is here to help. Be sure to subscribe so you don't miss our upcoming episodes where we continue to explore the critical issues that matter most during divorce. I'll see you next time.